Hello.
Yes,
Going live.
Standing. Just hold on.
Wait, Simon.
Yes, just a second.
Got a rise?
Mr. Mallard. Yes, I was going to take you to a document which I think my learned friend touched on yesterday that I thought I needed to show you a different part of. So I had just was talking about computer software and how it got into the case. Now, the thing that happened was, once the claimants had introduced it into their top 9, the first thing that happened after that, this was a matter of 3 weeks before trial, the first challenge to it came straight away in the Part 18 response by the defendants, which you'll see in the core bundle it's right at the back, apologise.
25.
Yes, 25, page 405. And they were asked 2 separate things. And it's important to keep these distinct because my learned friend has constantly conflated the IP translator uncertainty objection with the bad faith objection. Those were completely separate grounds of validity before the European Court. And they were asked, the defendants were asked here, 405, request 1, which ones lack sufficient clarity and precision? That was the IP translator question. And question 2, which of the terms in the list are alleged to have been in bad faith? Now, we'd had the terms, I think, then they'd emerged from this cast of thousands, 40,000, 30,000, plus you had class heading terms, so unlimited numbers. We'd had 9 or 8, as it turned out. They made a mistake even in the first group of things that they put to us. And we had 8 terms emerge. And we said we'd had them, I think, for a week by then. I'll give you the date of this. We say they've been filed in bad, all of them have been filed in bad faith, pursuant to an abusive strategy of filing for deliberately overbroad specifications so as to unfairly extend the proprietary rights of the claimant. This constitutes a ground of invalidity as a whole. So that's the sort of infection. Further and alternatively, in respect of the terms, so this is now looking at each of them, except telecommunications and email, they don't use or, they're so vague and imprecise and variable that they lead to unwarranted and unfair protection, and they don't reflect the claimant's business. And the claimants deliberately selected the terminology, the terms, instead of terms that more accurately and appropriately describe the goods that they trade in. Now that is key because that was fair and square our case throughout the proceedings. And that was the allegation, that was the point that was put to Mr. Tansey in cross-examination and Mr. Peers. And when the ECJ...
Just before you go on
Sorry,
to
yes.
your next bit, just pausing there, when you say the point that was put,
Yes.
I mean, there are various points in that.
Yeah.
On that page, can I focus on one of them?
Yes.
Which is 3.3. The claimants deliberately selected such terms in addition to or instead of terms that more accurately and appropriately described the goods and or services.
Yes.
Now, if we take one such term, computer software,
Yes.
you say it was it put that Sky had deliberately selected the term computer software in addition to or instead of a term more accurately and appropriately described the goods and or services?
It was put 2 ways. To Mr. Tansey, a large part of the cross-examination comprised the what you could call the funny stuff, the Gladstone bags and the stuff they'd never traded in. And there was a lot of it. Make no mistake about that. There was a lot of it. especially if you thought that the class heading, Mr. Tansey accepted this was the strategy, covered everything in the alphabetical list. So for that, you've got to look at your NICE classification and flip through fire extinguishers and abacuses and all the rest of it. Those are all in as well. So the cross-examination from our perspective was, so far as Mr. Tansey was concerned, who was of course not the man who was there anyway, but was going on what he was told, was to say, your policy was to apply for everything because it benefited Sky, and it was, you knew that the class heading covered everything with it, and he agreed with that. The second part of it, and this is a little bit, shall we say, less helpful even than that, what I've just said, is both I and the judge asked Mr. Tansey about this practice of belt and braces, duplicative protection. You've got computer software. It wasn't. I didn't say computer software specifically. It didn't matter because they were all. That was a class heading term. So I asked him about class heading, automatically covering covering everything in class, and then I said, what about following it up with a specific list? And he said, yes, that was a benefit to us. It gave clarity to other parties. Right? Now, on that, I asked him whether that was a benefit to Sky, and that effectively whether that's a warning to parties not to go near those goods and services, and he agreed with that. He didn't like the words warning sign, but he agreed that it was a benefit to Sky and it had a deterrent effect. So that was one part of it, my lord. The second part of it was Mr. Peers had put in, I don't know if you looked at his evidence, put in evidence of Sky's use in software. And he was asked about that. And this is important because the way my learned friend has characterised what the judge gave them on software is it's almost as if one would be left with the impression he's left with about 98% of what computer software is. It's the opposite. What the judge has given them in computer software is less than a fraction of a 0.1% of the possible applications of computer software in our lives today. The judge has essentially gone, I'm going to look at the use they've made on computer software, all of it, and I'm going to cut it down to that. And that was the purpose of of the Peers cross-examination. And I think you can, common sense would dictate that they, of course, haven't done accountancy software, they haven't done air traffic control, I mean, any kind of software you would think of, they have not done. But they've done a sliver. And the specific allegation was, you have acted in bad faith by adopting and actually duplicating and obscuring through the class heading computer software. So was it put on the basis of what computer software you have sold? That was more about Mr. Peers. In terms of why you applied for this, Mr. Tansey didn't know. He never, ever was able to assist because he didn't apply. And he was asked by the judge, is it true you left the technical matters to the legal team? He said, yes. We had no disclosure, no documents. There was an order for disclosure on bad faith, 0 documents on the basis of privilege. So no man, no documents, no explanation. What do we do then? Well, we have the ECJ judgment, and you've seen essentially the Advocate General was not just advising on the test, but advising the court that Sky, what they had done was bad faith based on the judgment. It fulfilled that test. It's quite clear. When a party does what Sky did, there is bad faith. Now, he's not going to decide for the National Court, but it's pretty clear. That's why my learned friend is so keen to paint him as something of an outlier, an maverick or something. The Court of Justice then rule with the test, and I wanted to show you what happens after that. That's the Skykick unagreed bundle, and it's the letter of, just find it now, sorry.
Just while you're finding that,
Sorry.
do you just
Yes, my lord, sorry.
do you say that the Court of Justice adopted the same view as the Advocate General, or took a different view on this point?
We say that the Advocate General was the thread between the Cotton case and the ECJ in the Skykick case. So what happened was the Advocate General at paragraph 109 said, I would answer this question along the lines of Cotton, and then the Court of Justice says, as the Court of Justice, as the Advocate General in 109 said, and that's the key test. And there are two limbs. What was troubling the court before this case was really only quite a small question in the end, which is, do you have to have abuse in relation to a specific party? Because all the cases thus far had been on that fact pattern.
Like Lind.
Like Lind, and even Cotton was a specific party. Or do you have some general against many parties? Now, Cotton did actually mention that, but it's quite clear that there was background communication between the court. I say between the two courts. I say that because the Advocate General Cockott in the Cotton case referred to our case and the arguments that we had run specifically. So, she knew quite a lot about our case, and there was cross-reference between them. They're all of a piece, my lord, we'd say. But anyway, during the on the return leg, as it's sometimes called.
I'm not clear what the answer to my lord's question is about whether the court agreed with the Advocate General in this.
In this respect, I see. You're quite right. I didn't answer the factual question that was asked. In respect of his opinion about Sky's behaviour, no, they never would. They leave that to the National Court. Advocate Generals quite frequently go a little more into the facts, a little more deeply, as my lord I'm sure knows. But when they get called out specifically in the ECJ judgment, that's quite significant. If they're ignored, you can potentially put them to one side. But if in the key reasoning they are referred to, we say they had well in mind the Advocate General's views of Sky, but it was not for them, it's for the National Court to decide. So if you take the Sky bundle, tab 23, Sky unagreed, not the confidential. Volume 1, isn't it? You'll see quite an important letter, I think, for this part of the case. And this has an effect on extent of validity, it has an effect on bad faith, and it has an effect on my learned friends' attempts to resuscitate different goods and services. Well, we wrote to, Field Official wrote to Mishcon de Ray on the 27th February 2020. It was the first contact after the ECJ judgment. And it sets out the position of our clients in summary form. So we're expecting a hearing to come up soon, and this is the position. We characterise the CJEU judgment. We say in the penultimate paragraph, it provides a clear answer in this case. Your client's claim should be dismissed, its trademarks very substantially invalidated or construed in such a way that there's no infringement. We accepted that there remain some uncertainties. I won't go into those because they're not relevant. We did actually mention that there could be the prospect of a further reference, rather in those halcyon days of early 2020, but fairly deep into the transition period already. Which goods and services are an issue? We talked about the best goods and services. We listed them, and we asked that they confirm that everything else was formally withdrawn. They didn't. I'll put Lords out of suspense. We then said, if they provide confirmation, we'll back that off to the registrar. Now, in relation to the 9 goods and services, we said that each of them is exceptionally broad and covers goods and services within which Sky had no intention to use and was deliberately framed in such a way as part of the strategy of acquiring exclusive rights. We quote 250 of the judgment. We quote the 3 ways. The hidden terms in the class headings, the fake terms that would never be used, and the overbroad drafted terms. And we say that these were all registered in bad faith except for the ones we had not attacked. And we said over the page, and this is the critical part, we anticipate that your client will seek to argue either that it intended to use the mark in relation to goods or services that are properly, albeit broadly, described by the term, and that your client should not lose the whole term if it intended to use the mark for some goods. In our view, the first of these arguments would be misconceived, and we ran our blue pencil argument. On the second argument, we say, as things stand, these terms include an almost limitless number of goods, and therefore, we say, as things stand, we say they should be invalidated. Now, what we say is all set out here, and we then go out into the IP translator point, and we tell them essentially that ask them what their case is. What is your case? We're telling you what ours is. What is your case? The answer we get back is in the Skykick bundle. And that's a letter from Mishcon Durea, dated is, I believe, 27. The little bundle. Sorry, can I have yours? We refer back to your letter.
We'll have to tell us where it is.
Sorry, tab 27 of the little bundle. It's the volume 2 of the Skykicks bundle. And in that, they say, well, they don't state their position. They say what they'll do is let's just agree directions and go to the hearing before Mr. Justice Arnold. If you look over the page, we suggest the parties serve skeleton arguments. And that's it. So we hear nothing from them on the way in which they should be narrowing their terms. And it will come as no surprise that when we come to the hearing, well, it wasn't a hearing, it was on the papers, we do not get a proposal from Sky as to any use within the term or any proposal to narrow the term. Even if we're in bad faith, which we're not, we lose nothing. That's the submission. It's been a bizarre one, thankfully. And the position is, therefore, we have a judge who then reaches a finding based on bad faith. In his judgment, in the three ways, he takes into account the proceedings, he takes into account section 32.3 lie, to the partial lie, to the registry, and he concludes that he's going to trim these terms back. That means this judge considers that these terms were applied for in bad faith. And he specifically calls out the terms in question. I wonder if I can show you what we said in our skeleton argument for the hearing before the judge. We said the onus of proof, and I won't turn it up, we said you have failed to set out an amended specification. You have failed to say which of the use, for example, for computer software or any of the things that you say you do, you have failed to show those to the judge. The burden of proof the onus has shifted. That's the key point. The onus has shifted. Now, my lords, this is an important point and possibly one of the most important points in the appeal. Where a party does nothing and says nothing, in circumstances where the prima facie facts indicate bad faith, or at least behaviour that is consistent with both good and bad, on Sky's case, but we say it's not really consistent with good. But in these circumstances, where there's a prima facie case of bad faith to the objective standards, the party can't run away and win by doing so. He can't keep quiet and give no documents and win by doing so. That is what Sky are asking you to do. They didn't put up the man, and they didn't put up the documents. And the judge was alive to this, by the way. Paragraph 240 and 241 of the judgment, he specifically says, Sky have not disclosed any contemporaneous documents. In seeking to resolve these factual issues, the starting point is that Sky have not disclosed any contemporaneous documents setting out, let alone explaining, justifying their filing strategy and their reasons for seeking broad protection at the relevant dates. The evidence doesn't explain whether this was because it was never recorded, whether it was destroyed, whether it was privileged. It would be wrong to draw an adverse inference to Sky, but nevertheless, the absence of such documents means it's necessary to look elsewhere. It's not about adverse inference. It's about shifting the burden of proof. If you don't answer the prima facie case, you should hardly be surprised that it is answered for you. Now, he then goes on in the next paragraph, 241, as explained, no one from the Sky IP legal team gave evidence, and in particular, their reasons for seeking such broad protection. The only witness who gave evidence was Mr. Tansey, but his evidence was that he took advice from the IP legal team. You can't hide behind privilege in a case of bad faith, where the prima facie case has been made against you. Now, computer software, my lords, fell into two of the judge's vices. It was an example of choosing a word that is so broad that it covers almost everything we do in life, and yet really only needing it for something to do with telecommunications, which is what he gave them in the end. So that's the first vice. The second vice, of course, was the what my little friend I think called the coded. That's a nice way of putting it. The coded use, the obscure use, the masked use that it carried in the class heading. And they admitted to it. And computer software in the judgment was specifically mentioned as examples of that. And the temerity to come before this court and ask for that to be the paradigm example of how they haven't acted in bad faith, because the chair in Entertainment General Court, which was dealing with the IP translator question, and therefore said it's clear and precise from that perspective, but therefore it's somehow blessed for all purposes, including bad faith. Lord, that conflates, again, the IP translator question with bad faith. We had a judgment in the third judgment at paragraph 20 and 21 from the judge saying, not merely did they not intend to use, but there was no foreseeable prospect that they would ever intend to use the marks in relation to such goods and services. They made an application pursuant to deliberate strategy of seeking very broad protection, regardless of whether it was commercially justified, and they backed it up with threats of infringement claims or actual infringement claims or oppositions with third parties. My Lord, at this point, all of the goods and services were under question. At the very latest at the third judgment, did Sky offer to trim back their marks even then? No. On the contrary, they sought to ambush Skykick on the computer service Whatsit. And even now, they come before the court without a shred of contrition, with no apology at all, and with leading counsel saying big brands should be able to get anything they like. Big brands get registration by the act of registration. They get title by the act of registering. Perpetual. Trademarks last forever. Most IP rights expire after a certain time, even copyrights, which last a hell of a long time. These things can last forever because a big brand decides to. Now, we need to show you two authorities to show what should happen in a case like this where a party folds its arms. The first of them is a case called Ferrero's. It's a judgment by Lord Kitchen, but then he was just Mr. David Kitchen QC sitting as the appointed person on appeal from the Trademarks Registry. Do you have the copies? You can have one copy. I think my learned friends have got this.
This is your reply speech on bad faith.
This is on extent of validity.
Citing new
Well,
new authority.
this one's actually mentioned in the judgment, my lord. It's not a new one. It's mentioned in the judgment of the judge, the main judge. Just a bit of background facts. The Ferrero company had basically stockpiled and applied for a large number of Kinder marks.
Could you just tell us what proposition you're citing for first?
The proposition is, when there is a prima facie case of bad faith, you've got to answer it. If you don't answer it, you lose the lot. And that's essentially the finding. It is clear from this, he says, Mr. Rickard suggested that there was a prima facie case of bad faith through the sheer number of registrations that had been built up, and Kinder or Ferraro did not answer it. The same point is made in the monopoly case.
Is there a particular paragraph?
Yes, which paragraph would it be? 17, I'm told 17 and 23. Yes, that charge was clearly advanced. So I'll probably pick it up. To my mind, the points do not assist the registered proprietors because they do not answer the central charge that the very large number of unused registrations and applications indicate that the registered proprietors were filing applications to register trademarks without having any genuine intention of using them. That charge was clearly advanced by Mr. Rickard and again by Ms. Bucks, but has never been addressed by the registered proprietors in evidence. In all these circumstances, I believe that the hearing officer was entitled to come to the conclusion that the applicants had established a prima facie case that the registered proprietors did not have a genuine intention to use on the dates they'd filed. He was also, in my view, entitled to come to the conclusion that the prima facie case was not answered. And that's all we ask. The prima facie case was not answered. It was open to the judge to take the view that in the absence of any documents, absence of any witness, and the monstrous scale of overclaiming on its face, unexplained, you could assume that the case was not answered and that the onus had shifted. For what it is worth, we don't take out procedural rules from the European Court of Justice, but it is helpful to know that in Monopoly they said exactly the same thing. The General Court said exactly the same thing. There's a number of cases in the... We've got a note, I thought, on Monopoly, but I don't think I need to pass it up. I don't want to give too much more paperwork to my lords. But I took the court to this case, and essentially the proposition is that it's much the same. It is in the hands of the proprietor to know what was intended. They know what was going to happen, what planned use, what was speculative, what was abusive. If they've got a story to tell, in a case of evergreening, that's a prima facie case of abuse. But there may be an explanation. We're trying to rescale our branding, we're moving to another firm, or whatever it might be. We don't like the goods of that previous one, we think they're not well expressed. There might be umpteen reasons. There might be umpteen reasons here, but my lords should not assume anything for them. Some of the questions that were put to me, I mean, my Lord Justice Floyd, what about the IT outfit who applies for computer software? That's not them. The IT provider who applies for computer software is not Sky, knowingly and duplicatively burying the term in its class headings and multiplying it through various marks. And that's just one term out of many that the judge has found. It's not a case... trademarks, especially bad faith cases, should be really judged on their own facts. My lords, let me make sure I've got that. This is just 1 second. There's a paragraph missing from that note. My lords, is it the top point? Paragraph? Yes. So for my lord's note, it's 43 and 44 of monopoly. Once prima facie bad faith has been established, it falls to the proprietor to explain itself, because the proprietor is the only one with the material and evidence to explain itself. So, Lord, I now want to just look at what happens, where that gets us in terms of the other issues. My learned friend said the other argument that he justifies on bad faith, and therefore that he should void extent of validity, is he says, well, lots of others were doing it. It was the presidential communication. No evidence of that at all. That's exactly what they did in Monopoly. In Monopoly, they said others are evergreening. Court of Justice said, well, they might be committing crime. They might be breaking the law too. We just don't know about that. The only evidence in the case was that their mark was extremely long, far longer than any normal mark. I think I've addressed you on my learned friend's point about title by registration or of registration. We say that's contrary to the scheme of the legislation. It cannot be right. You can apply it, register anything you like.
Right. I know that these issues do interrelate.
Yes, they do a little bit. I'm going to just
reply
move on from
that.
I thought Malone would say that.
Your appeal.
Yes,
and
yes,
we're
yes.
quite a long way from your appeal, I think.
Yes. I'm going to focus on the extent of validity, and in particular the point about the ECJ judgment. If you look at the ECJ judgment, my learned friend took you to paragraph 79, where it says covered by. And what he didn't take you to, and I asked him to, was paragraph 80, the dispositive paragraph, where they set the test. And that makes it clear, we say, that you are talking about invalidity affecting registered goods. It's an abuse of language to talk about registered goods being goods that are invisible. I mean, we're back in the IP translator days now. Something covered, something implied. That's not what's on the register. So if my learned friend is saying that in circumstances where he's got a finding of bad faith because he drafted wide, that he should still be able to collapse that down instead of blue pencil, we say that's not what the court said. They quite clearly, we say, indicated that it should be registered. But in fact, the policy arguments, which is of course how you should always interpret European judgments and cases, are very much in my favour, because I think I mentioned this, but I'll repeat it for my lords, because I don't think there was an answer to it. If you narrowed down to what you would get, what they would have got anyway, how is that a meaningful consequence of the bad faith? You're not.
Well,
it's being treated essentially as
you do that, you remove the part of the mark which is registered in bad faith and leave them with what they could have got in good faith.
Absolutely, my lord. What they could have got in good faith.
Yeah.
But here, it's not like a distinctiveness objection.
You say they should.
Yeah, I mean, it's not like
punish them and
if
reduce them to nothing.
It's not. No. Well, first of all, you've seen the trademarks. Each one of these terms was copied out 5 different ways, and that's or still in the mark. They're losing nothing. The marks have been gracefully withdrawn with the same terms in 1,000 different ways.
If your argument is right, they should lose everything else as well.
Well, if they had maintained them in infringement proceedings, yes. Not the total infection though of the whole mark. That was the law actually before we went to Luxembourg. That changed. So now it's those goods and services only. But it's those named goods and services. It's not, well, the ones, there's nothing in the ECJ judgment that says subject to the proprietor being able to demonstrate good faith. No, the grounds of invalidity, which have been bad faith, are those registered goods and services only. That's the simplest course, my lord, but actually we don't have to die in a ditch on this, actually. Because in my submission, if you are with us on bad faith, the right course is either blue pencil or stay with the judges level. We're both gravitating back towards the judges level of cutback. But bear in mind, what was the procedure, the fundamental procedure the judge adopted? He was adamant that computer software is extraordinarily broad, as my Lord was, Lord Justice Floyd, in the Galileo case. It is a huge term. Everything from, one-thumbed games on your iPhone to the tube navigation system. Everything is computer software. So it might look like he gave them quite a lot. No, he gave them quite a little, and it was supposed to be married to the evidence that they had shown, plus a bit more, in the teeth of Sky submitting or requesting him to do everything. If you approach construction with those eyes, it's very surprising to think that in a real-world business, it starts to become much more what Sky are really doing, not just some notional trademark claim, and what Skykick are really doing. And what's been happening is whizzy software as a service, migration and backup provided to partners for their Office 365 systems. And Sky, with telecommunications software-ish and a bunch of other bits of amended specifications, that the judge has approached on the basis, I'm going to tailor this more or less to what Sky do, and maybe a little bit of a penumbra. You're very unlikely to reach a judgment on infringement and construction against my clients in circumstances where we've had side-by-side trade. There's no overlap. We trade extensively in this country. It's not as if we're in another country only and therefore confusion doesn't come to light. Sky are huge. It's a big name, accept that. Not that well known, but it's very well known for some things. No confusion. Why? Because they don't have a reputation for these goods, and on their face, what the judge gave them should not be enough to cover what we have done or what we have done in any of the parts of our business. Let me just check my note for just if there's one. It was said, why didn't you revoke on non-use? There was no point, completely pointless seeking to revoke. Footnote 13 to our skeleton, we explained that the youngest mark was still in being and still within its grace period up to the day of the form of order hearing. And that was the long one. It had everything. So not much point doing that. Would we have done better revoking? I'm not sure. The judge, we say, was quite generous when it came to the bad faith, but maybe we could have. But my Lord, this is what it comes down to. Once all is said and done, you have a party who clearly has acted in bad faith, seeking to restrain, like a dog in a manger, a party who has nothing to do with what they do, and the judge sought to reflect that in the specification, but there are parts like email services that one still has to contend with, and the rather confusingly worded computer services. But really, that's what it comes down to after all these very difficult and I hope interesting issues, my Lord. I'm grateful, my Lord. That's nothing further from me.
Mr. Hobbs, you must at least have a right to respond on Ferrero. I don't know whether you think you have a right to respond on anything else.
Can I just make three staccato sentences?
Not relating to Ferraro.
One is Ferraro. The first is Ferraro. The first is, it is settled law that the opinion of an Advocate General is not binding on the Court of Justice or the referring court. That is absolutely settled law, and he knows it, not least because it came up in Interflora as part of the judgment. Ferrero, there was a prima facie case of no intention to use. No intention to use was equated with bad faith under Section 3.6 of the Act. There is no way in the current state of the law in which you can equate simply no intention to use as a prima facie case of bad faith. And a lot of what you were hearing just now was a somersault in relation to SciTech. The third point is the last one he's raised. The judge he didn't rule explicitly. The judge said explicitly in paragraph 7 of the main judgment that he didn't accept and explained why he didn't accept what my learned friend has just yet again reiterated, that somehow or other there was no point, they couldn't have done it, they could never have amounted a revocation for non-use attack. And the reason why I mentioned that is, it is untrue to say that trademarks last forever. The whole purpose of the revocation for non-use provision is to ensure that they don't. And that's really my staccato points.
Mr. Manager, I haven't quite worked out whether you ought to have the final word in relation to the staccato points, but...
I'm very grateful for my Lord's kind offer, but I shall decline.
Good. Well, you will be surprised to know that judgment will be reserved. It will be made available, as usual, for you to deal with typing and similar corrections and not to re-argue the case. I'm not sure whether judgment will ultimately be delivered remotely, as has been the fashion, or in court, but of course either way there'll be no need for anyone to attend. And again, saying what I know you know already full well, we would be grateful if you would seek to agree an order dealing with consequential matters. If there are any points of difference, we'd like brief written submissions on those, and we wouldn't expect to deal with them otherwise than in writing. Let me finally, I hope, thank you all very much for your very interesting submissions.
May we thank your lordships for your patience and attention, and may we say to you that if there is any assistance we can give you with logistical matters, documents or anything that you want followed up, please don't hesitate through the usual channels to make it known.
Thank you very much. We'll leave it there.